Morning.
Good morning.
Morning, Enos.
Morning, Jen. How are you?
I'm good, thanks. Oh, well, hope you are too.
Great stuff.
We're ready. Enos, when you're ready.
Oh, yes, I'm ready, Wayne. We can start.
Over to you, Enos.
I can't see slide, Wayne. You're not moving my slide. Good. Good morning, everybody. Welcome to all the participants who are attending our webinar this morning. Thanks for making time to be with us. I'm struggling with my camera here. Just a moment, just give me a second, please. Colleagues, I'm sure most of you are aware that a certain portion of the Protection of Personal Information Act, known as Popia, became active as of the 1st of July. Today we are hosting our first session on Popia to provide a general overview of the Act itself and the legislation. We will be hosting a second session on the 14th of August this year. And of course, I'm sure during our discussion, a lot is going to emerge that we can also use in our discussion on the 14th of August. Of course, the session will be focused on the retirement funds and what the funds themselves need to do. Today, our main speaker, as you know, is Boitumelo, Magolego, I'm sorry for that, who is a member of our Legal and Technical Committee at the Institute of Retirement Funds Africa. We are also hosting a panel that will provide an input on the questions that are going to be put forward by our participants. As you know, Popia will have a big impact on all of us. And therefore, we urge our members and the participants to really invest their time in learning more about this piece of legislation. Thanks for making time, for joining us this morning. I'll therefore hand over to Boitumelo. Thank you very much.
Good morning. Thank you, Tumi. Over to you.
Thanks, Wayne. Good morning, everyone. My name is Boitumelo Magolego, as the president introduced. I will be giving you a high-level overview of the Protection of Personal Information Act, which largely came into effect on the 1st of July 2020, with a one-year transitional period, which puts us at about 26 June 2021 in order for which to comply with. I will be taking you through the background and application, demonstrating compliance with Popia, failure to comply with Popia, and at the end, we will have a question and answer session. Just to repeat what the presenter said, that we will be having a second session, which will focus mainly on the impact of Popia on retirement funds. So for now, this is just a general overview of the Act. Okay, so here we just have a timeline which just shows where this all began. On the 19th of November 2013, Popia was enacted. It came into law. On the 1st of December 2016, our Information Regulator, Mrs. Pansy Tlakula, was appointed. On the 8th of September 2017, the draft regulations were published for public comment. And on the 14th of December 2018, we had the final regulations which were published for public comment to be in effect on a date to be determined by the Information Regulator. And then on the 1st of July 2020, we had the commencement of the Act, as I said, with the one-year transitional period. So Popia, as I keep mentioning, is just short for the Protection of Personal Information Act. And Popia is South Africa's data protection law. So Popia was enacted to protect personal information, and it applies to the processing of this information. A responsible party who can either be a public or private body who processes this personal information will again have a one-year transitional period in order to comply with the provisions of this Act. So what is personal information? Personal information consists of information like your age, your race, your gender, your religion, information like addresses, your education. And what is personal special information? So personal information will consist of things like your trade union membership, your alleged criminal behavior, your political persuasion. And now that we know what personal information is, what is processing of this personal information? This will include things like your collection, your collation, your using of this personal information, and even altering personal information will be considered processing. More commonly, even storage of personal information will be considered processing. Okay, so in terms of the Act, we have role players. Your data subject is a person to whom the personal information belongs. Then we have your responsible party, as I've mentioned. This can be either a public or private body. Then we have your operator. This is a person who processes the personal information on behalf of the responsible party. So a common example of this would be where a third party is appointed by a responsible party to store their data for them. That kind of individual or person would be considered an operator. Then you have your regulator, which means the Information Regulator, as I've mentioned, who happens to be Ms. Pansy Tlakula. Okay, so what does Popia not regulate? Popia doesn't regulate things like your pure household activities, information that has been de-identified, information by or on behalf of public bodies. Those are just examples of things that Popia does not regulate. Okay, so in order for a responsible party to be deemed as compliant with the Act, these 8 conditions must be complied with. The first condition would be openness. This is where a data subject must be made aware that their personal information is being processed. Then you have your security safeguards. So basically, a responsible party needs to have security measures to make sure that the integrity and the confidentiality of the personal information is being protected. Then we have data subject participation. So this would entail the fact that the data subject has rights to their personal information. So this would even include a data subject requesting that a responsible party delete their personal information, as well as requesting access to that information. Then you have accountability, which relates to a responsible party being accountable to comply with all these 8 conditions. And then we have your processing limitation. So this just means that the personal information must be obtained through lawful means with the necessary consent and within the necessary limitations. Then we have your purpose specification, which says that the reason for collecting that personal information must be specific, it must be defined, it must be clear why you've collected this personal information, and it must be for a lawful purpose of processing. Then we have your further process limitation. This just means that the reasons for collecting must be compatible with the processing. So you cannot collect personal information and process whichever way you want or for any other reason other than what you've specified you're processing the personal information for. Then the last one is information quality, which speaks to the information being complete. It must be accurate, it must be correct. And the snag here is that the personal information must be frequently updated, which obviously then would pose practical, will have some practical implications, meaning that you'd have to now locate your data subjects and make sure that the information is up to date, it's correct, and so on and so forth. So I wanted to touch on consent, which in regards to data marketing specifically. So what is direct marketing? Direct marketing is approaching a data subject for the purpose of promoting goods or services, marketing your products via electronic communication. So electronic communication would include things like your SMSs, your voice message or MMSs, those annoying automated voice calling machines. That's electronic communication. And then your data subject must consent to have being able to receive this direct marketing. So if your data subject opts out, you must always provide the option to opt out. And when the data subject opts out, you can no longer, as a responsible party, continue to send or promote or offer goods and services through electronic communications towards that data subject. The regulations also, the final regulations, which are not yet in effect, also provide a form in which this direct marketing must take place, or the form for the consent rather. Okay, and then I've illustrated just the differences between the information regulator and an information officer. So let's start with the information regulator. So an information regulator is a very, very key person. This person works with the information regulator, and they are responsible for the development of the compliance framework in an institution organization for the responsible party. They encourage compliance with the Act, and they also deal with the Popia requests. And then the information regulator, on the other hand, is responsible for monitoring and enforcing compliance with this Act. So they will issue draft codes of conduct, they will issue infringement notices, they will issue codes of conduct, infringement notices, do investigations, handle all the complaints, and so on and so forth. So the information regulator is basically the enforcer and the individual that regulates the enforcement of this Act. So these are the sections that are actually coming to effect, the chapters rather. I'm not going to take you through the detail, but I will just go through the chapters just to give you an idea of what's actually coming into effect. So chapter 1 is a purpose. Chapter 2 is the application provisions. Chapter 3 is the conditions for processing, which I've taken you through. So each of the conditions do have an exemption from being able to process the information. So that will be dealt with in chapter 4. Then you have chapter 5, supervision, chapter 6, prior authorization, Chapter 7, codes of conducts, which will tell you how the codes of conducts will be published, when they'll be published, and the process that's to be followed when they are published. Then Chapter 8, data, the rights of data subjects on direct marketing, which I've touched on. Chapter 9, which is also a very important chapter, which deals with trans-border information flows. This is, for example, where a responsible party or organization for storage purposes transfers data to a third party overseas for storage purposes on the cloud or things like that. This chapter will explain how that must be conducted. Then we have Chapter 10, which relates to enforcement. Chapter 11, offenses, penalties, and administrative fines, I will take you through. And then we have Chapter 12, which deals with the transitional arrangements. Okay, so failure to comply with Popia. So in terms of the Act, penalties for a breach in terms of this Act, a responsible party can be liable to a fine not exceeding 10 million or imprisonment of 10 years or even both. A magistrate's court can impose this penalty, so they do have the jurisdiction if you don't comply with the penalty that has been given to you. And if an information regulator issues an infringement notice, which states when and how much you will be fined, the Act says that you have 30 days in which to comply, or to rather to pay the penalty. So if you've got a fine of about 10 million, and then the Act says that you have about 30 days to pay that, it's a bit hefty. And then the Act also provides the criteria on which the information regulator will consider when imposing this penalty. Okay, so this is my last slide, but I just, out of interest, wanted to also just give you a run through on the General Data Protection Act versus Popia. So the EU General Data Protection Regulation came into effect on the 25th of May 2018. So this regulation basically regulates the PI of all personal information of all EU citizens, irrespective of their jurisdiction. So if you have an EU citizen in South Africa, the General Data Protection Regulation will apply to them. And these are some of the differences between Popia and the GDPR. So its application, Popia's applies to personal information which is processed in South Africa, whilst the GDPR, as I've said, is EU nationals anywhere in the world, citizens. The person referred to in Popia is natural persons as well as juristic persons, your companies. And then for GDPR, it only applies to natural persons. The role players in terms of Popia will be your responsible party and your operator. And in terms of GDPR, it's a data controller and a processor. The penalties, again, as I've mentioned, for Popia is a 10-year imprisonment or a 10 million fine. And for the GDPR, it's a whopping 20 million, or it can be 4% of your annual global turnover for non-compliance or a breach. The official responsible for encouraging compliance in Popia is the information officer. And in terms of the GDPR, it's your data protection officer. Data breach notification, in other words, when must you notify the regulator when there's a breach? In terms of Popia, it's as soon as reasonably possible. And for the GDPR, it's within 72 hours of the breach. So 72 hours from the time you became aware that there was a breach, you have to notify the regulator. Impact assessments, this speaks to when an impact assessment must be done or by who. In terms of Popia, the duty is on the information officer to conduct this impact assessment. And for GDPR, it's required to be done where there is high risk processing that is taking place. Data portability speaks to how portable the data is on request by a data subject. In terms of Popia, the data must be provided to the data subject as soon as reasonably possible in a manner and format which is understandable. And with the GDPR, it must be structured, it must be on a format that is commonly used, it must be machine readable, and it must be understandable. So those are a little bit more stringent than what is in Popia. Okay, and that is it from me, ladies and gentlemen. I think we'll be moving on to the question and answer session. Wayne, will you take over from here? Thank you.
I will. Thank you.
Thanks.
Thank you, Tumi. Over to our panel. Tumi, of course, will be part of our panel. We have Leanne van Beek and Chantal Manson joining us. I see I've disabled the video, so I'll see if I can re-enable it in the background quickly while we're talking. But to get started, we received several questions, and the questions we're highlighting here are the most common ones, and obviously we invite more questions. But I think we're going to start off with Chantal with Leanne for question one. Popia seems complex to comply with. Is that the case?
Thanks very much, Wayne, and good morning, everybody. Well, when you're answering this question, firstly, I think that Tumi did a great job of just simplifying it down. But for me, I think this is one of the most complex pieces of legislation to comply with. So I don't want to sugarcoat it. That is my true belief. But having said that, I think that it is obviously doable, and it has been done in other jurisdictions. And it's a matter of setting out, what we want to achieve and then going through the process to achieve it. I'm hoping that as the regulator starts to issue more guidance around, the various parts of what we have to do, it will become slightly easier. But in the meantime, I think that we can take a lot of guidance from what has been issued under the GDPR. And there are plenty of documents issued under the GDPR, as well as by the UK Information Regulator. So if I look, for example, at what Tumi said around the 8 conditions, I think what we need to remember, and what makes this act slightly more complex, is that each of those conditions have got sub-requirements. Okay, so for example, if you look at condition 2, which Tumi talked about, which is the processing limitation, there it's got a couple of sub-requirements, like the personal information can only be processed if the processing is adequate, relevant, and not excessive. It also includes, for example, that you've got to collect personal information directly from the data subject. So while there might be 8 conditions, we should not be tricked into thinking we only have 8 things to do, right? Because each of those 8 conditions have sub-compartments. Plus, there are quite a few more requirements. So requirements around account numbers, direct marketing, which Tumi already referenced, children's information, information going out the country. So there are 8 conditions plus other requirements. And then the other thing that makes this act quite complex to actually implement is that it gives a rule, and then it gives you 100 exceptions to those rules. Okay, so as an example, it will say to you, here are your 8 conditions, and then it will give you, within each of those conditions, usually when you don't have to comply with that condition. Plus, you've got general exclusions. On top of that, you've got your special personal information, where you've got rules around that. And then for each type of special personal information, you've got rules around what you can do with it and what you can't do with it. So there's a lot of detail in this act. And I think that often people, are quite scared off by that, because, in my experience, you pull one of the threads and out comes this big ball of wool that's all, tangled together, and you've got to tease out, the different parts of the act and how you're going to implement it. So yes, I think it is complex, but it is obviously doable. I see that we have got a question around, is the IRFA working on a code? I'll let Wayne answer that at a later stage. And I think I'll just finish off with my question there.
Great, thank you. It's a process. I think that's what we need to understand, and it's something that's going to evolve, and we're going to have to learn to live with this and be aware of changes and our behavior and our practices. That sort of leads me into the next question, which I'd like to ask Chantal. Is the responsible person or party, for example, a retirement fund, responsible for compliance of its operators, in this instance, say, for example, an administrator, with Popia?
Morning, everyone. So Wayne, the simple answer to that is yes. And the reason why it's yes is that, as Tumi took us through, most of the responsibility in the Act actually resides with the responsible party, and the obligations to comply with the A conditions and to lawfully process the personal information resides with the responsible party. In the instance, like the example we've given, where a retirement fund might have an operator such as the administrator, where the administrator is processing or further processing personal information on behalf of the retirement fund. What the Act requires is that there must be a written agreement in place between the responsible party as well as the operator, and that agreement needs to make sure that it sets out that the operator will be, it sets out under what conditions can the operator actually process that personal information. It needs to make sure that the operator's security measures, which are referenced in the Popia Act, are also included, and that the operator is able to fulfill that. So while it might seem that operators have a lesser compliance obligations in terms of the Popia Act, what usually happens, or what we've seen happening, is these operator agreements are a lot more fleshed out in terms of what the responsible party expects from the operator, because the operator is almost essentially doing the functions that the responsible party would have been doing. So they are very, very contractual terms, very detailed contractual terms in terms of what's expected from an operator. So let's say, for instance, there is an instance of non-compliance with the Popia Act by the operator. The Information Regulator will be seeking to, or going to, the responsible party as the first port of call to understand exactly what has happened, and will be holding them accountable. But if the non-compliance has happened through the operator, the rights of recourse that a retirement fund might have to the 30B administrator won't be that they have breached the Popia Act, but it's more so that they're not fulfilling the contractual terms that have been entered into between the two parties. So just to recap, the Popia Act requires that there must be a written agreement in place between the two parties, being the responsible party and the operator, and it needs to make sure that it clearly sets out the expectations and what's required from the operator, where they are processing or further processing the personal information on behalf of the responsible party. And also a key thing to consider is, luckily Anne said, Popia is very complex. There are so many layers involved in here, so many different parties involved. So the key thing here is that the funds, as a responsible party, need to go and understand what are their requirements. How will they be able to demonstrate that they're taking reasonable steps to ensure that either they are complying, or if they are making use of an operator, what governance and oversight structures have they got in place to ensure that their operators are able to process the personal information in a lawful manner with the right security measures, so that if something does go wrong, or if there is non-compliance, at least be able to demonstrate what steps have been taken to mitigate the potential enforcement action, which, like Tumi mentioned, could be 10 million rand or 10 years imprisonment. So while it might seem like this is a mammoth task, that you just take baby steps at a time and be able to demonstrate exactly how you've applied your mind as a responsible party, what steps and controls you're putting in place, and just be able to demonstrate that you have taken reasonable steps to comply with the requirements, and that if you are making use of an operator, that you have got sufficient oversight on that operator, and making sure that they understand what's required from them in terms of the contract.
Thank you, Chantal. So, and I think you mentioned it, and just for my clarity, and maybe for some of the people listening, it definitely is going to mean that there's going to be changes to contracts and addendums to contracts. And it definitely means that you're going to have to put in that governance practice of ensuring that whoever is providing the service to you is doing the right thing.
Correct.
Thank you.
When
Yes?
I think it goes even further than ensuring they're doing the right thing. You've actually got to ensure that they are compliant, or you have evidence around their compliance, because I think that it's going to be very difficult to show that you've complied with your own responsibilities as a responsible party if you can't show evidence of your monitoring and supervision of operators. So it's going to become very clear in a very short amount of time that responsible parties are only going to use operators who can demonstrate their compliance with Popia. Under GDPR, it goes even further. You have to give guarantees of compliance, but that's not a requirement under Popia. But certainly, I mean, if you look at this in a fund context, your funds will definitely be looking to only appoint service providers that are compliant with Popia and can provide evidence of that.
I know. I mean, that makes a lot of sense. So, I mean, when you're doing your due diligence, besides checking all the normal things that you check, this is definitely going to be a further and a big part, I think, of what you'd have to add on to when you look at processes and whatever programs, systems, and things your operators are using. So there's work. I think the important understanding here is that everyone needs to do something and start sooner than later, I think, as far as this is concerned, and start asking the questions. I think this takes us next to our next question, which is the question 3. And Tumi, I want to ask you, does every responsible party have or have to have an information officer? For example, does a fund have to have one?
Okay, so Wayne, again, the short answer of this is yes. In fact, there was a draft guidance document that was published by the Information Regulator on the 17th of July, which tells us why we need to have an information officer, who needs to be an information officer. I mean, for example, it even includes provision that an information officer should be the head. In a private institution, it should be a head who is the CEO or equivalent. But Chantal, do you want to elaborate on this, please?
Sure. So this was a very opportune time that the Information Regulator published this draft guidance, I think, to be mentioned on the 17th of July. Both a private body and a public body needs to have an information officer. So obviously retirement funds and most of our service providers would be a private body and a juristic private body. And like Tumi mentioned, the definition of who the head, and they said the information officer should be the head of the private body who's a juristic person. And in this instance, it's actually the CEO or the managing executive of that juristic person or that private body. However, they can duly authorize another person to fulfill that function on being the information officer. So they really are elevating the importance of making sure that an entity complies with Popia, that it resides with your senior management, it resides with the top management of an organization. So the guideline also sets out that depending on the size and complexity of the body or the juristic person, you can appoint more than one or appoint deputy information officers. And the guideline also says that each information officer or deputy information officer has to actually be registered with the Information Regulator. And they've given a deadline of the 31st of March 2021, which sounds like it's quite some time away, but the advice or recommendation is rather establish or identify who's going to be the information officer, either for your retirement fund or if you're a service provider, who's going to be that person within the operator or responsible party, because this person has got a huge responsibility and numerous things that they will be held accountable for. So rather let that person be identified so that while the retirement funds or boards are busy going through this journey of understanding what it's required for them from Popia, this information officer should be part of that journey, because the duties and responsibilities of information officers, which is set out in the regulations of the Act, is, they are responsible for developing implementing a compliance framework. They need to make sure that the adequate measures and standards in place within the responsible party. They have to develop manuals. They have to do awareness and training sessions. So if that information officer is not identified upfront while you're going through this journey, they're going to be on a back foot in terms of what's actually required from them and from an understanding point of view as well. So rather try and identify who you think the information officer should be for your entity with the retirement funds. I know the IRF has made submissions quite a while back to the Information Regulator, suggesting that perhaps it should be the principal officer of the fund is the person who should be the information regulator. If, and alternatively, if the principal officer is not that person, they can then obviously designate or delegate or appoint someone to be a information officer, particularly for the fund. But the submission that the IRF made was prior to the guideline coming out. So we're going to have to relook at the submissions that we made at that point in time to see whether there's additional, or there probably will be changes that will need to be made when engaging with the information regulator, very specifically for retirement funds, as to who's best placed to be the fund's information officer. And then also just, it's also worth noting that the Popia Act and the Promotion of Information Act, or Promotion of Access to Information Act, need to be read in conjunction because the two go hand in hand and cross-reference one another. So retirement funds did have an exemption in terms of the or the requirement to produce a PIA manual in terms of the PIA Act, but that exemption is expiring on the 31st of December this year. So we just need to be cognizant of this looming exemption being we're not too clear if it's going to be extended or not, but there is a requirement also under the Popia Act to have a manual in place in terms of how compliant or how a responsible party is complying with the Popia requirements.
Thank you, Chantal. That's a lot of information and valuable. As far as the PIA manual is concerned, I know there is work being done on that by the IRF as well. So hopefully we'll have more information on that shortly. Want to move on to the next question, and want to direct the question to Leanne, please. This is a general session. Just to remind everyone, the next session will deal very particularly with retirement funds. So the aim for today was more to provide general information so that we'll become aware of what Popia is, and then drill down into the retirement sector in the next session. That said, question 4, what are the legislated things to do for responsible parties under Popia? Leanne?
Thanks, Wayne. So I think that there are a number of things to do for responsible parties under Popia, but I think what we need to be careful of when it comes to Popia is not just doing compliance for compliance sake, right? There are certain things that we need to tick off our list, but we also need to get to the end result, which is protecting personal information, because there are a number of overriding provisions in the Act which require us to protect the privacy of data subjects. And what we've seen in the past with respect to other countries is that if you take simply a compliance approach and you don't actually put effective measures and safeguards for risks in place, and you do have a breach, what happens is those parties end up putting all those really effective safeguards and measures in place once they've already paid the fine and had the bad publicity, because there's nothing juicier to the press than a privacy breach. It's a very widespread, easy thing to report on. So if we look at Popia and just some of the things that will be required to be done if you are, when you're putting together your structured approach, whoever you are, whether you're a fund or an administrator or a consultant or whoever is doing the processing. Some of them we've talked about during our previous questions and Tumi's presentation. So I'll gloss through those and just spend a bit more time on the others. So the first one is obviously identifying and authorizing your information officer as well as any deputy information officers. And we see that there will be specific requirements around that, which have just been provided in a draft notice. Then obviously we're going to have to register our information officer. So that's a process that we will have to all go through. And then there are a number of requirements around when you have to go to the information regulator and get authorization for specific types of processing. So there's specific things that if you do them, you have to go to the regulator and get authorization to do them before you do them. So if you have not got your authorization before the end of this year we've got to comply, you're going to have to stop that type of processing until you get your authorizations. So these prior authorizations, as they are called, should be done now during our year to become compliant. Examples of those types of processing where you have to go to the information regulator and get authorization is if you are processing, for example, unique identifiers. Unique identifiers are specifically defined in the Act and are really around numbers that are allocated to data subjects so that they can access money or credit, etc., etc. So if you're processing unique identifiers, another one is if you are sending children's information out to a third party in another country, and that country doesn't have adequate protection around personal information. Another one is if you are processing criminal behavior on behalf of a third party. Again, there you would require prior authorization. So the examples, those are three examples of types of processing where you have to go and get prior authorization from the information regulator before you process. Then we've mentioned agreements with operators already. So hopefully, you know, many companies have already started doing this type of amendment or addendum to their agreements. So, you know, it should, hopefully there won't be a rush right at the end, but my advice on this is do not leave it to the end, because sometimes these clauses actually take some time to negotiate. So you don't want to leave no time for negotiation. Then in terms of Popia, the information officer has to implement a compliance framework for Popia. Okay, now some companies, for example, administrators will already have compliance frameworks and they will need to work Popia into those. But other entities such as funds, as an example, I think that there are very few funds that would have a compliance framework, let alone a Popia compliance framework. There are lots of compliance frameworks that you can look at off the shelf. You know, there's ISOs and all sorts of other compliance frameworks that people have come up with. None of them are really specific to retirement funds, as an example, so they would require some work. Those sort of compliance frameworks involve quite a bit of work. So before you can get to a compliance framework, there will be a whole lot of preliminary work to do. For example, mapping out your information flows or your activities, training that has to be done right up front before you can do it. So that type of data mapping, gap analysis work is all within this compliance framework requirement. And then we've mentioned manuals. So as Chantal said, that PIA manual that we all got exempted as funds from doing, that will become a requirement as of December if there's no further exemption. Popia did amend PIA to some extent, so our manuals do have to include slightly different requirements, and I know that the IRFA is working around that. But your manual will then be both a PIA and a Popia manual together. Part of that manual work is who has access to information, how they can get access to it, what sort of information you hold, who they can get hold of to get access to their own information, etc. And part of that will be, and this is another step towards compliance, if I can put it that way, is developing your own internal measures to process requests from data subjects. So when people come to you and say, I want to know what information you hold about me, or give me this information that you hold on me, or they are requesting specific information around decisions or whatever it is they're requesting, we need to have a process and systems in place to deal with that, as well as information in our manuals. Then in addition, we have to have internal awareness sessions. So these internal awareness sessions are legislative requirements. So it's not a nice to have, it is something that we have to have. In the latest notice or draft notice from the Information Regulator, she actually talked about the fact that the awareness sessions had to include provisions, training about the provisions of Popia and the regulations to Popia, any codes of conduct that are issued and are relevant to your business, which there are no relevant ones at this stage, but we expect them to be issued as and when industry bodies or the Information Regulator starts considering them. And then that awareness program also has to include any information from the regulator. Now, I assume that what is meant by that is where the regulator has sent out some type of guidance or directive, then the business should be made aware of that, or the entity itself. And that awareness is an ongoing thing, so it's not a once-off, we've done it and now we're good. Then another legislative requirement that we must bear in mind is that every responsible party has to do a privacy impact assessment. So as Tumi said, under the GDPR, you only have to do a privacy impact assessment or a data privacy impact assessment, a DPIA as they call it, when there are high risk activities involved. However, under Popia, every responsible party has to do a privacy impact assessment. Now, again, that privacy impact assessment, what it is aimed at is ensuring that the responsible party has got adequate measures and standards around complying with Popia's 8 conditions plus the other requirements. So the idea then is to, firstly, it usually involves a systematic analysis or description of the processing that you do. So you identify the type of processing you do of personal information. Then you identify protections and processes for the risks associated with processing that type of special information. And you also identify whether when you are processing, you're complying with the 8 conditions and other requirements that are set out in Popia and by the regulator. So basically, it's an assessment of your risks and your lawfulness, and then what you're going to do about your exposures and, by setting measures and setting standards to deal with them. So that privacy impact assessment is something that has to be done. Then perhaps the last thing to mention is documenting and evidencing. It's very important that when you are doing all this work around Popia, that you properly document and evidence the work that you have done. I mean, this is for a number of reasons. When your privacy impact assessment should start that documenting and evidencing. But if you are subject to a data breach or to an investigation by the Information Regulator, as an example, it'll be very important to show what you've done to ensure compliance with Popia. It'll be important to the penalties that you face, as an example. It'll also be important, and I know this is not set out in the Act, but it'll also be important to reputational damage. You know, if you can show that you did what you should have done, that will go a long way to mitigating perhaps penalties as well as your reputational damage. So that's just a sort of whirlwind tour of some of the things to do with respect to Popia.
Thanks, Leanne. I see there are quite a few questions. I don't know if we're going to get to them. We might have to send a written Q&A later. I would like us to try and get through through the rest of these questions quickly. Question 5, I want to direct towards Chantal. And Leanne, there's a lot. Just as a side comment, clearly it's a process. We all need to start that process. Chantal, should all operators be treated the same way?
Wayne, my view is no. There are, especially in the retirement fund sector, there are a multitude of operators that are involved within a retirement fund. I mean, you've got your administrator, your asset consultant, your financial advisor, your insurer, your tracing agent. There's a whole host of operators that are involved within the retirement fund value chain. And I think it would be almost impossible to treat them all in the same way, and because all you would be doing is just Popia compliance if you're imposing the same kind of requirements on all your operators. So the key thing is, you know, operators are doing different types of processing or different types of further processing. They're also processing different types of personal information. So the key when it comes to operators is firstly, like Leanne mentioned, is identify who all your operators are. And thereafter, you need to go and risk rate your operators to understand exactly what kind of level of due diligence or oversight or involvement would be required from you in respect of that type or in respect of that particular operator. So the risk rating or risk factors that you would need to consider is what type of information are they processing? Is it special personal information? Because special personal information has got even higher protection afforded to it, and you need to make sure that, you know, an operator who's processing children's information, health information, that type of stuff has got the necessary security measures, because if there's a breach on special personal information, you'll be found to be winding a lot more because of the extra added protection that the Popia Act gives to special PI. You also need to consider, you know, how often are they processing this personal information? Do they have the necessary safeguard measures in place? Are they able to give you the certificates that they've got the necessary IT security measures in place that will give you some sort of comfort versus someone who might not have that? Are they potentially processing personal information outside of our borders? Are they using cloud services? Because there's also additional requirements or factors that need to be considered if the personal information from of the fund or from the responsible party is being used outside of our borders. I mean, how many data subjects, personal information are they processing? There's a whole list of factors that need to be assessed against each of the operators. Luckily, identify what personal information does the fund process, which operators are processing or further processing their personal information, and then risk rate each of the operators to understand exactly what sort of oversight and governance and MI you need from those operators in order for you to be satisfied they're able to meet their obligations.
Thank you. That's very helpful, and again speaks to process and getting your action plan into place. To me, I think this sort of leads to the next question, which I want to ask of you to give us a response, is if you get consent for everything, will that mean that you're compliant?
Okay, so it will mean that you are processing information lawfully. However, a data subject can at any time withdraw their consent, or they can object to a responsible party processing their information, which means that a responsible party can no longer process that information. And since the consent has been withdrawn. Also, internationally, there are requirements that consent be renewed every 2 years. But again, that also poses it also has some practical implication going to go look for data subjects in order to retrieve that consent each time. And also there is an exemption for where responsible parties cannot obtain that necessary consent. So it's not always required to get that consent for every single thing. The Act does provide exemptions there.
Thank you, and I think that's something we'll definitely touch on in more detail in the next session when you think about administrators, insurers, and all the things related to the administration of funds. But that's very helpful. Thank you. And I want to try and stick to an hour. I know we've budgeted a little more time, but I know generally people don't have the extra couple of minutes. But this last question, and this question I want to to ask Leanne to give us a response to Kofi and Popia. Where and how do they interact? And what do we know so far? Because I know the one's still in progress and the other one is now more finalized.
Yeah. Okay. So Kofi has got a very interesting, let me go back a step. Kofi is the draft legislation that is aimed at supervising or regulating the market conduct of financial institutions. So it's the FSCA's legislation around market conduct of all the financial institutions in our industry, including obviously funds. So it's got a very interesting section, and it's section 34, if you want to go and look at it. And basically what section 34 says is a financial institution, which as I said would include a fund, an administrator, etc., may not disclose or use any personal or confidential information acquired or obtained from a financial customer except in accordance with Popia. So basically what Kofi does is it incorporates Popia and says that financial institutions can't process information from financial customers unless they do it in terms of Popia. But why I find that interesting is that it then means that not only is the Information Regulator responsible for supervising and regulating financial institutions with respect to Popia, but so is the FSCA. And my question would be how this is how the two are going to work together, because the Information Regulator is really a super regulator in that they regulate other regulators as well. For example, the FSCA as an example. So all the enforcement mechanisms that the FSCA would have with respect to COFI and the Financial Sector Regulation Act as an example, would be able to be used against a financial institution who is not processing their customers' information in terms of Popia. But equally, the enforcement mechanisms under Popia can be used against those same financial institutions by the Information Regulator. So I'm not sure yet that the Information Regulator and the FSCA have worked out how they will be working together and who will
I'm not sure if it's just on my side, but Leanne is hanging a little there. Yeah.
No, she is frozen there, Wayne. And also, I just wanted to add to that, we're seeing this more and more where because we've got so many regulators at a national level as well as a sectorial level. And similarly with the transformation requirements that we've been discussing within the retirement fund sector, the FSR Act also gives as an objective to the PA and the FSCA transformation of the financial services sector. So where we've got this national legislation, we're seeing our sectorial regulators also who've got line of sight with the financial institutions pulling in this national requirements because they interact a lot more closer within their industry on these issues as opposed to an information regulator who has to look at everyone. I mean, they're from mining to health sector to the government, and they're a team of 4 or 5 people. So it's almost impossible for them to supervise such a wide range of entities. And this is probably why they're starting to pull these into or putting it into our sectorial law or the COFI bill and the FSR Act, because our regulators have line of sight with us as financial institutions and are almost able to wave the stick to us to make sure that we are complying with these other requirements.
Thank you. I think this is definitely something we will be taking up. There is a meeting scheduled with the Information Regulator and IRFA delegation, and I know this is one of the issues that is going to be raised, and the FSCA is also joining that meeting. So hopefully it will be a fruitful discussion. Yet again, haven't looked at the latest release from the Info Regulator, so there might be some information there. But we will keep everyone updated. I think some of the questions and comments we've received will be fruitful to answer maybe in a Q&A. aside and probably also carry over to the next session. For everyone to get back to work and their other activities, I would like to propose that we close the session and invite Enos Ngutshane, our IRFA president, to close the proceedings for us. I'm just going to invite Enos to, there we go. Good. Welcome back. Thank you, Enos.
Thank you, Wayne. And let me take this opportunity as well to thank Tumi and our esteemed panelists. I think they did a very, very good job. Thank you very much for your inputs and your insights. I also realized that we had a number of other questions, but as Wayne has promised, we will be responding to those through a Q&A. And if you still have further questions, you may direct your questions to our email, info@irfa.org.za, info@irfa.org.za. Thank you very much for participating, and we will be happy to receive your feedback on how we can improve our service offering. Thank you very much. All the best.
Thank you.
Thank you all. Thank you.
Bye.
Bye.
Thanks so much. Bye.
Bye.
Oh, there's Leanne. Bye.